Can I do a sound check? Am I able to be heard? This is Nicholas Fowler.
I hear you loud and clear, Nick.
Yep.
Great, thank you. And I apologize, my video won't be on. I've got a very narrow bandwidth line, so I'll have to keep my video off, but I hope the other commissioners can keep their video on so I can see who wishes to speak and so forth. I see that it is 6 o'clock, and so why don't we begin? We are at the finish line, and so let us try to be efficient and effective this evening. And I'll begin by thanking Vice Chair Heyman for so ably chairing the meeting last week that resulted in a decision. But let me now call the roll. Commissioner Bisco.
Here and a sound check.
We can hear you. Commissioner Cash.
Present.
Commissioner Fulford. Commissioner Fulford, I think your audio was off. Maybe if you unmute, we can check your sound as well. At least I am not hearing you. I am seeing you. So we'll move. We know you're present, and it sounds like.
Can you hear me now? Yes.
Yeah, now we can hear you. Thank you.
All right.
Commissioner Lee. Thank you. Commissioner Struthers.
Here.
Commissioner Wilson.
Here.
Vice Chair Heyman.
Present.
Very well. I will note for the record that we have a quorum. And Commissioner Cash, as you were not present for the meeting last week, and our bylaws are not clear on whether it's permissible for you to vote without having been present for deliberations. I invite you to participate in all of the meeting, but we won't be recording your vote. I apologize for that. Our bylaws are not clear.
Understood, Nick.
Thank you. And per usual, I've got some things to read into the record before we can begin. This is the time and place for the continued public hearing in the matter of LU-24-027, an application from Republic Services for a conditional use permit to expand an existing landfill. This is a continuation of the quasi-judicial hearing previously held on April 29th, May 1st, May 6th, May 8th, July 8th, July 9, and July 22nd, 2025. The purpose of this continued hearing is for the Planning Commission to adopt the final written decision and findings of fact and conclusions of law that planning staff has prepared in support of the Planning Commission's July 22nd, 2025 decision to deny Republic Services application for a conditional use permit to expand an existing landfill. At the July 22, 2025 continued public hearing, Commissioner Struthers moved to deny the application based on evidence in the record and findings in opposition and conclusions developed by the Planning Commission at the public hearing. The motion was seconded, and after deliberations on the motion, Commissioner Struthers amended the motion to specifically include Commissioner's opening statements. The Commission deliberated on the amended motion and voted 7-0, with Commissioner Cash absent, in favor of the motion. The public hearing was recessed until tonight in order for the planning staff to prepare the final written decision, including findings of fact and conclusions of law. So our sole agenda this evening is to adopt the Planning Commission decision made on July 22nd. The record is closed and deliberations are concluded. This meeting does not reopen deliberations. We're here to adopt the decision and findings. It has not been the role for the Planning Commission to write those decisions and findings. The staff writes them. I'll readily acknowledge that the decision and findings document is not how I would have written it, and I'm betting that it's not how any of you would have written it either. but anyone who's been charged with writing up consensus from a meeting of 7 very active participants can appreciate just how difficult a task it has been for the staff. The document should reflect our intent and our conclusions. Each of us has spent many, many hours listening, reading, digesting, and pondering the many pages of written testimony and hours of oral testimony. So it's natural that we might feel somewhat let down by this document when all of our effort is boiled down to a few pages and we don't explicitly see our words, our sentiment, or conclusions reflected directly. We need to remember that this document is not a union of all of our work. It is the intersection that reflects those conclusions that garnered a majority view. As we review, there is a spectrum of potential input. That spectrum could range from correction of errors all the way on the other end to matters of writing style. Certainly correcting errors is exactly what we're looking for, but what we're not looking for is to comment on matters of style. In that middle gray area, those areas that might make us feel uncomfortable or even squirm a bit are not exactly, and they may not exactly be errors, but any proposed edit that we discuss should be simple and straightforward so as not to jeopardize the schedule and must reflect the majority intent of the commission. Should the applicant exercise their right to appeal to the Board of Commissioners, we want to ensure that the board has sufficient time to exercise their process. So with all of that said, I would like to entertain a motion from the commission, and the form, let me see if I can find the form of the motion that Ms. Ryan provided for me. Here it is. The form of the motion should be something as in, I move the Planning Commission adopt the written decision and findings prepared by planning staff in support of the Planning Commission's July 22nd, 2025 decision to deny the application. Once the motion is made and seconded, we'll open the floor for some discussion. I see Commissioner Wilson, you have your hand raised.
I do, Chair Fowler. I was going to make that motion, and I was listening intently to what you read from the script that was provided to you, but I'm not certain that I'd be able to incorporate it all, as I don't know that I can do that after one pass. And I don't have it in front of me. It was not included as a part of our material. So, but I can entertain the motion if I can get as close as possible.
Right. The form of the motion is something to move that the Planning Commission adopt the written decision and findings prepared by planning staff in support of the Planning Commission's July 22nd, 2025 decision to deny the application.
Okay. I move that in the matter of, excuse me, LU 24-027, that the Planning Commission adopt the Planning Commission decision regarding denial of the conditional use permit and the accompanying report that was prepared by the planning department for the commissioners. Is that close?
By George, I think you've got it. So could I ask for a second?
Second.
Commissioner Fulford has seconded, and so the matter is open for discussion. Commissioner Fulford.
A quick point of order. I did have a correction on my attachment. I argued to 53.215, but I referenced 53.220. And so I've corrected that and sent that attachment in. It's basically a couple small changes in the document. But it makes sense. Instead of arguing to the conditions of approval, it's arguing to the criteria which the whole document's built around.
Chair Fowler, can I add then to the motion that in the adoption of the prepared document and the attached opening statements provided by the commissioners, that in the case of Commissioner Fulford, that his amended opening statement be adopted in the official record?
What I'd like to do, since there may be a number of proposed amendments, we will act on each amendment, and then as motion maker, Commissioner Wilson, I'll ask that whether you're amenable to amending your motion to incorporate those amendments approved in our discussions.
Oh, yes, I am. Thank you.
So is there a second to Commissioner Fulford's proposed change to the written findings?
I would second.
Commissioner Hayman has seconded. Any discussion on the motion made by Commissioner Fulford?
I would like to make a couple comments or corrections, possibly.
We'll do them in order, Commissioner Lee. So we'll dispense with the motion made by Commissioner Fulford, and I'll come directly to you next.
Chair Fowler, I just have a
Okay.
quick question. With that in mind, with Commissioner Fulford's amended statement, are we asking that his original, the original statement that was included that had the typographical error, I suspect, of just referencing the wrong code, do we have that withdrawn, or does that stay and the commissioner's amended opening statement stays as well?
If I could jump in here, Chair Fowler, I think the plan was to correct the typographical error and change the reference from 220 to 215.
Sounds great.
And that's all. Okay.
Very well. Then I will ask then for a vote on Commissioner Fulford's correction of some typographic errors. All those in favor signify by aye.
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 Any opposed? Thank you. That has passed. Now we'll move to Commissioner Lee.
Thank you very much. So when I read this document, I found, just as you described, Commissioner Fowler, Chair Fowler, areas that I did not recognize. And some of them rise to my belief that they are omissions. And so I would like to present my case that they be changed. And in one case, I have a simple one-word change that could resolve the issue, and in the other, I don't. There's just some, well, you know me, I just read things and I read them carefully. So I want to be sure about the meaning. So beginning on page 4 of the document, weighing of evidence. So I'll try to go chronologically through the document. I believe we discussed this during the deliberations, and Missy Ryan asked the question verbally, are you giving preference to the testimony given by the public and their consultants? And I heard more than one voice, including my own, say, no, we are not. So there wasn't a real vote on whether there was an agreement on that statement. So I'm confused as to why this statement appears in this document when I believe we made it clear that that was not the intent. In fact, when I was looking at this, it was my understanding that the applicant, that my justification was based on the applicant and the application. And while I valued and appreciated the public testimony, and the public testimony gave life to my justifications were based on the application itself that included inconsistencies, assumptions, and deficiencies, and that those in themselves would have been ample basis for denying the application. So to me, the application itself is evidence, and that evidence failed to meet the burden of proof that the expansion would meet the criteria of 53-215. So this is the one I don't know how to quickly change in one word or not. I would say the Planning Commission finds the testimony and evidence submitted by I wouldn't say it that way. I would not say that. It was unnecessary to say this because the application itself was its own evidence. So should I go through my other points of discussion, or should we open this one to the group to feel out?
Well, do you have a proposed change that that the group could consider?
Is this section required in this document? Weighing of evidence. I guess I would say the Planning Commission found the testimony and evidence submitted by opponents. I don't know. I don't know how I would write. I did not plan to have to rewrite this. Sorry.
Well, and we're not looking to rewrite the document, but we are looking to make sure it is an accurate reflection of deliberations.
Well, then I would say some planning commissioners found the testimony and evidence submitted by opponents, including but not limited to testimony and evidence submitted by VNEQS and Beyond Toxins to be more credible than testimony and evidence submitted by the applicant's experts, and the county's third-party reviewers. Not all planning commissioners required that
So
that change in credibility. I don't know.
Yeah, and we need to be very careful that we are not reopening deliberations. And so we need to look at changes that are discrete and correction of errors. But let's get a couple of the hands that are raised. Commissioner Bisco.
Yes, Chair Fowler, thank you. So I'm going to go back to Commissioner Lee's question, which is that statement required in this document? Because I too don't agree with it. I believe that I know in my testimony, and I heard in others, references to inconsistencies in the application and applicant's testimony, inconsistencies, discrepancies, omissions. I know I also called out their inability to answer what I would consider fairly basic questions. And so let's circle back to the question of, is that statement required to be in this document? And if not, I would recommend that we remove it. I find it inconsistent with our deliberations.
Commissioner Struthers, you have your hand raised.
I actually would like the question to be answered as well. And I actually would like to thank you, Chair Fowler, for your sort of statement that this may not be the way you were in the document, because that is the one section where I'm not quite, that's not how I would written that. I actually had to go back and watch our meeting from that night, from last week. And we actually didn't discuss the weighing of evidence really at all. I actually timed it was 1 minute and 15 seconds that this was sort of asked, and then we sort of pivoted to other discussion. And so I don't think we actually discussed the weighing of evidence and came to a true consensus.
Okay, I will ask Council Ryan, is that sentence required in the document?
It is not required. It is helpful to let the Board of Commissioners know when the Planning Commission is engaging in a weighing of evidence, but it's not required.
Okay, I would then look to Commissioner Lee's comment as a motion to delete that sentence. Is that accurate, Commissioner Lee?
That would meet my needs, yes.
Is there a second?
A second.
Any further discussion? We'll call for the vote on the motion made by Commissioner Lee. All those in favor signify by aye.
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 Opposed? That sentence is deleted. Commissioner Lee, you can move
Yes.
on to your next comment.
The next comment is also on page 4. The sentence starts, the Planning Commission finds the character of the area to be largely urban and rural residential uses. I found that to be very strange. I would certainly not characterize the area to be largely urban. I would suggest that a change would be the Planning Commission finds the character of the area to be diverse, a diverse mix of ag, forest, wildlife refuge, and urban and residential uses.
I would observe that this falls dangerously close to wordsmithing and matters of style. So I do want to be careful that we're not attempting to rewrite the entire document. I believe, if I don't mean to put words in your mouth, but it is the word urban that is troublesome.
It is the entire concept that the character of the area is largely urban and rural residential uses. That excludes the large wildlife refuge right next door, the agricultural and forest working lands. I mean, that statement is just absurd to me. It's for many reasons, and one of those reasons is that it assumes that the character of the area is defined by the space on Highway 99 from North Corvallis to Coffin Butte. What about the areas to the north, west, and east? So that statement, that first line, is absurd to me.
Comments about
This
that line?
sounds, Chair Fowler, a lot. Yes, this is sort of heading into revisiting deliberations again. My recollection from the meeting that was a few of the commissioners did raise the issue that is addressed in the findings, and I do not recommend reopening this issue because it would reopen deliberations which have not been noticed.
And we certainly don't want to open deliberations. So on.
I totally agree, but I mean, am I the only one who read that and went, whoa?
I did read that and I reacted to urban, the word urban, and I thought it was restrictive, but I dismissed my concern as a matter of style as opposed to matter of substance. Commissioner Biscoe, you have a hand raised.
I do. If we were to look at the generally accepted definitions of urban and rural residential, do those definitions include the farm, forest, the agriculture, production, and all the things that Commissioner Lee inquired? Because if not, then that is a factually incorrect statement. And since it it leads into the whole character of the area, which is part of Benton County Code 53.215. It seems important that we are accurate in that statement. I don't feel that it represents how I perceived or presented that area when we talked about the character of the area either. So I'm not sure what the resolution is, but it appears to me when you look at those definitions of how it's written that it's factually inaccurate. I'm not sure that's a deliberation, I guess is my point. I think it's a correction.
So where it gets into deliberations is trying to rewrite it. If we delete it, then I don't think that is going back into deliberations.
So how about this? Here's a compromise. Just remove the word largely. The Planning Commission finds the character of the area to include urban and residential uses.
I'll look to Council Ryan to confirm. That doesn't sound like we're reopening deliberations.
That sounds fine.
Commissioner Bisco.
Yes, thank you, Chair Fowler. Again, I find that statement is even if we remove the word largely, is still factually inaccurate as to the character of that area. And because it's in code, it seems important. So I'll go back to your question about if we deleted it, can we then re-propose? So it's not a deliberation on that statement, but can we re-propose a different, I didn't hear like a resolution. If we were to delete it, do we just delete it and move on? Or can we propose an alternative?
Well, I don't want to get into wordsmithing and creating this document with 7 or 8 of us trying to chime in on each sentence. So very simple fixes, such as Commissioner Lee has suggested, I think falls within our realm to consider. Going much beyond that in terms of constructing new sentences, that worries me.
How about a compromise to the compromise? The Planning Commission, let's see, where did it go? Finds the character of the area to be diverse and to include urban and rural residential uses.
I'll ask Council Ryan whether we are overstepping our bounds there.
I think you probably are overstepping. I think that any discussion that heads in the direction of what was said, or I remember I remember thinking last week, or this was my position, a specific commission is really for deliberation. And so I understand, countless hundreds of hours on this, but this sounds a lot to me like things that should have been discussed during deliberations. For example, we talked a little bit during deliberations about the meaning of some of the phrases in the code, but we did not talk about the meaning of the character of the area. That was one thing that we could have talked about and nailed down, but it didn't happen.
So Commissioner Lee, your previous compromise sentence appeared to be acceptable within the constraints of not reopening deliberations. Would you like to phrase that as a motion?
Okay. You want me to phrase it as a motion? Okay.
Yes, please.
So I move that this statement on page 4 change to state the Planning Commission finds the character of the area to include urban and rural residential uses.
Is there a second to the motion?
I would second that.
We have a duly made and seconded motion. Any final discussion? Commissioner Bisco.
Thank you, Chair Fowler. I do have a final question, but before making that comment, could Commissioner Lee please restate her proposed wording again?
Yes. The Planning Commission finds the character of the area to include urban and rural residential uses.
Okay, thank you, Commissioner Lee. So I will just point to Council Ryan's comment that this Planning Commission did not, and I'm generally capturing what she said, did not really discuss character of the area. I then find that staff has put that definition in there. I'm concerned about the term urban. When I think urban, I think downtown Eugene, downtown Portland. I don't think Corvallis even is urban per se, by definition. And so I'm curious why we would include a definition that was created without Planning Commission discussion of character of area and really admittedly just now by staff. I disagree with the definition wholly if we're going to include urban and cannot revise it otherwise.
Appreciate the
revi-
comment. In the interest of time, I'm going to call for the vote on this particular one. All those in favor of the motion signify by aye.
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 Opposed?
Oh,
Opposed.
Motion passes. Commissioner Lee, I believe you still have another suggested correction?
I do. I believe this is just a correction. It's on page 6, fire services. The Planning Commission concludes that the landfill use will unduly burden, fire services provided by Adair Rural Fire District, which is small and comprised of volunteers. I think if you just add largely of volunteers, because it does have at least one paid staff.
Very well. Is there a second to that correction?
I second.
Any further comment? We'll call for the vote on this minor change. All those in favor signify aye.
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 Opposed? Change is accepted. And Commissioner Lee, do you have another?
I have one more right below that, water facilities. The second line after the comma starts, due to the transmission into the Willamette River of PFAS from leachate. I would just delete PFAS and just say of leachate, because the concern is a range of toxins, including PFAS, and leachate, the word leachate covers all of it. We are not just concerned about PFAS from leachate. We're concerned about all of the leachate.
Okay, is there a second for that change?
Andrew, I'll second.
Comments on this suggested change? And Commissioner Bisco, I see your hand. Is that for this comment, or is that okay? Thank you. I'll call for the vote on this suggested change. All those in favor signify by aye.
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 Opposed? Change is accepted. Does any other commissioner have a correction to make in this document? Commissioner Bisco.
Thank you, Chair Fowler. There is one to get started here is that we have defined, let me get back to the document here. We have not defined adjacent. And I recall a number of commissioners and in our deliberation having conversations about what is the definition of adjacent. More commonly accepted is that shared property line with the landfill or buffer zones. I believe that we should define for the purposes of this record or this document what I believe to have been the intent of adjacent was not just those immediately sharing property line properties, but more of a regional definition. I'm not sure if that's the word we want to use, but I would like to see us acknowledge our deliberations in that word adjacent, meaning more than just what has commonly been accepted in the code definite. Well, there is no definition. What's been commonly accepted, I guess I'll just say.
That sounds like deliberations to me. I do recall the commission agreeing during deliberations on Commissioner Fulford's proposed definition of undue burden, and also the definition of seriously interfere. I don't recall anything during deliberations that discussed the definition of adjacent. I remember some of the opening statements proposing what each particular commissioner's view of the meaning of adjacent, but I don't recall any consensus on that. So I feel this strongly that this reopens deliberations.
And to be clear, Council Ryan, then if something was not actually come to consensus in the deliberation process, then does that not meet what is required for it to be entered in this record? Because I see topics of which we did not vote on the housing consideration either, and I see that as part of the findings in this document. So I'm not sure that we actually formed our deliberations on a matter of, is there a consensus of the Planning Commission for the opening statements and the deliberations?
I guess what I'm saying is I don't remember any discussion during the deliberations portion of any particular meaning of the word.
I'm losing Council Ryan almost
Yes,
every time.
I did
Agreed.
too. Agreed. Yes, I've lost her completely.
Sorry, I'm on vacation, so I have a little bit of spotty cell coverage also.
We
would
understand.
observe. I would observe that the motion that passed unanimously a week ago referenced opening statements, and those opening statements included those from Commissioner Fulford, who I believe was the originator of the housing references. And we did vote on that to incorporate those opening statements. And so that was something that was voted into the during deliberations as something that was included in our decision.
So going back to our, thank you, Chair Fowler. So going back to our deliberation discussions, we did not vote, I don't think, on anything other than that final vote to include those opening statements, which presents itself as we will be incorporating what's within those opening statements and the deliberations that occurred on last week's meeting. So to be clear, how did we decide which of those opening statements were incorporated into this document and which ones were not? Because a consensus process is not how we framed the deliberations, nor any content from our opening statements.
So the original motion was amended to include opening statements, and there was a call for those opening statements to be delivered to county staff to be incorporated as supplemental findings in this decision document.
That's correct, and I understand that part. Thank you again, Chair Fowler. But my question is, how did staff determine which elements of those opening statements and our deliberations at last week's meeting to include in this document? Because I do not see, I'm not sure that I see represented all of the things within those opening statements. Certainly some of them are. So I'm just looking for clarification on how was it decided by staff what to extract from the deliberations, conversations, and what to extract from these opening documents?
I am not able to answer that, but I'm trying to understand the significance of that since the opening statements were incorporated as supplemental findings.
Okay, I'll step back this way then, if I may. Thanks again, Chair Fowler, for trying to answer a question that I'm asking that I'm not sure that we all have the answer to. In my opening statements, excuse me just a moment, the ones that I read largely from, and then having that written as a read verbatim and including also conversation and reference to materials when I was giving my opening statement. In the third paragraph, my opening statement reads this: adjacent properties, quote unquote, for the purpose of this hearing related to criteria found in Benton County Code 53.215 has been determined to far exceed the immediately adjacent by, quote, shared property lines property owners, with documented risks and impacts as far as North Albany, Airlie, Independence, in Polk County, South Corvallis, Lewisburg, Philomath, and rural unincorporated areas of Benton County. I guess that's my point. So that was part of my opening statement. I know that we've acknowledged that. I can't cite where everyone else is, but I don't feel that I stand alone in that. And yet I don't see it in this document. And I think that that definition has relevance here because it is outside of the normally how we interpret, and the Planning Commission has the ability to interpret it. It's outside of how normally, maybe just because of the size and scope of the impact of this, or just because of the complexity of this record, but we did acknowledge adjacent properties. And I'm looking to get that in this document.
Statement is in the incorporated findings. It is a part of the findings. What I'm advising tonight is not for the Planning Commission, not to.
Yeah, unfortunately, Councillor Ryan, we are not
Sorry
able
about my
to
internet
follow
connection.
your statements.
Planning Commission not have a about what it began.
Was not able to hear
Can
Councillor
you hear
Ryan.
me?
No.
Let me try to turn my video off. Can you hear me now?
Yeah.
Commissioner Bisco, the statement you just read is part of the incorporated findings, so it is a part of the findings. But what I'm suggesting that's shouldn't happen tonight is deliberating as a body on what the meaning of adjacent is. That did not occur last week, and it cannot occur tonight. The findings are necessarily abbreviated. They're not going to be as comprehensive as the entire record, but your statement, including everything in it, is part of the findings.
So I respectfully disagree that this should not be in those findings. And I disagree fully with findings being abbreviated. Having reviewed 50 years of this land use record, I feel that's a risk that not only disrespects the comprehensive nature of this application and the public testimony, but it also leaves open risks for any potential appeals that may occur out of this space or any potential future applications out of this space that looks back to this document and says, well, that's not in there, which is really what you're doing right now. Well, that's not in here, or staff decided that the findings will be abbreviated, so we're not going to include the definition of adjacent. Now, if in fact that needed to be done that night when we were discussing other definitions, then I would have relied on council and staff to point that out. But because opening statements were intended to be part of this, and then this process was not very well defined as far as what this meeting would be this evening, I disagree with that statement and disagree with findings being abbreviated. I'll be clear here. Do I have the opportunity to present this as a motion, Chair Fowler, to incorporate that definition as in the opening statement that was read, not objected to either? So it wasn't discussed, but it wasn't objected to either. Meaning we didn't take any.
I am deferring to Councillor Ryan that such a motion would essentially or explicitly be reopening deliberations. You can create a motion to reopen deliberations, recognizing that reopening deliberations would put the schedule in jeopardy. It would basically eliminate the opportunity for in a robust appeals process, hypothetical appeals process, but it would obviate the ability of the Board of Commissioners to manage a robust appeals process. So you may make the motion to reopen deliberations. There are risks associated with that.
Very good. Chair Fowler, then I make a motion to reopen deliberations, recognizing your statement that it would put a potential appeal in jeopardy, but I feel that an incomplete findings of record here for reasons for denial would also put an appeal in jeopardy. And that providing the Board of Commissioners a clarity on something as important as adjacent, if you look to see how often that's referred to in our record and in the public record testimony, but also in this document, I think it's important that we as a planning commission define what that was presumed to be for this entire process.
So I'm going to truncate your motion to are moving to reopen deliberations.
Thank you. Yes.
Is there a second on that motion? I see none, so the motion dies for want of a second. Do you have additional corrections you'd like to propose?
Yes. Let's see here. Many documents. Give me a moment here to locate the correct one. I would like to change the word experts in this document, which is often cited in testimony and evidence submitted by the applicant's experts, and the county's third-party reviewers. It is most often cited in relationship to public testimony, which I believe we have documented in this record. We have a number of professional experts, doctors, highly educated. The list was read in our discussion, but I take issue with the word experts, and I think that a better word might be consultants, because there's a wide definition of expert to disenfranchise all of the actual professional experts that testified seems to me to be inaccurate in this document. So my proposal is we change the word experts in this document to consultants. I don't know that it's used anywhere else other than related to the applicant's consultants.
Is there a second to Commissioner Bisco's proposal?
I would second. This is Andrew.
Comments on the change from experts to consultants? I will then call for the vote on the change of experts to consultants. All those in favor signify by aye.
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 Opposed? Change passes. Commissioner Bisco, do you have more?
I do. Getting to the right place in the document again. Excuse me for the delay. Not trying to have that happen by any means. I am not sure if this has been answered already, but I do want to point out that when reading the opening statements, which of course was part of our deliberation and discussion last week, I am seeing what appears to be 12 findings. When I go back and read Chair Fowler's, Commissioner Fulford's, Commissioner Lee's, and my submittals for those opening statements, which of course were part of our deliberation, I find that we have 67, near as I could. So Chair Fowler's, yours were a little bit more narrative version, but just trying to give a good guess of what could be turned into 67, and some very explicitly, depending on who wrote them. So Commissioners Lee's, and I know mine as well, to an extent, findings for reasons for denial. I'm a little bit unclear why we only have 12 and has been mentioned. They were, I don't know if it was abbreviated, but I do wish to point out some of those emissions, and I'm not sure what that process is. For example, litter, and maybe this is just a change, but the litter, I believe it may not have been in seriously interfere, but wherever litter is sitting in the document, it does not address what was in the record about the highway litter. It only addresses the litter as it relates to agricultural lands and livestock around it. I recall that
Yeah, and I'm gonna interject here, Commissioner Bisco, because this falls into the category of the document is not an exhaustive union of all of the proposed criteria on which the commissioners felt that the application was deficient. There's some judgment here. The staff is responsible for writing this, and we need to respect their judgment and not attempt to rewrite the document.
Okay, so to the extent then, with that comment being made, for what I believe to be omissions of some key findings, we have no mechanism to revise this document, just for a point of clarity.
So rewriting the document would essentially be reopening deliberations. And we've already had that motion. Now, if there is a clear error, we can address it. But I don't think we can go through a list of things that were omitted either unintentionally or intentionally by staff. We need to rely upon their judgment. It is their responsibility to write the document. I see a hand raised from Commissioner Struthers, a comment.
It is a comment, Chair. Thank you. And Commissioner Bisco, I understand where you're going, and I'm trying to find, and I've heard what Councilor Ryan has said as well, that what was written in the staff's findings, or what was provided in that document, is, for the lack of better terms, and this is my wording, right, the summary of what we discussed last week. But on top of that, everything, all the statements are being added as supplemental findings. They are part of the findings. They are just not summarized in the main findings. And so those, what you referenced, 67 or so other findings, are part of the overall document. It's just they're not summarized. You just have to read through all 54 pages to get this. And to sort of find a good way to a metaphor for this, and I apologize if this is not a proper place to discuss to make up a metaphor, but with the first 6 pages could be, you could consider, the document coming from a judicial ruling, because we are acting in a quasi manner, so we're acting as in a judicial way. All the other is additional statements to support those findings, or support those additional findings. So I would, from my viewpoint, all 67 are being included in those findings, because these statements are being included in the overall findings.
And thank you, Commissioner Struthers. I appreciate that. I will use an example of where I feel like that's just deficient. So part of the conversation was bioaccumulation, for example, of particulate matter. Particulate matter is not, and that was extensively discussed in the record and also in our discussions. I'm not seeing that in these findings, or I'm also not seeing closure and post-closure, which obviously if you have a landfill, there needs to be proposals for that closure and post-closure. That was absent or insufficient in the record as well. So I hear what you're saying, and I respect that, but having, navigated through the Benton County Talks Trash process and recognizing how a lot of the findings that you could read in the documents were underwound by either legal loopholes or manipulations, I'm concerned that those additional things that are in our opening statements are not going to be held with the same force in any appeal situation or any future, any future situation. I feel like it's weakened the document by not including those. So I will just make that statement. I think you've all heard where I'm coming from. Another important one for me is the health impacts has not been mitigated, measured, or otherwise. And that too did not rise to the level of staff believing that has merit in this final document. So I'll stop there. I think that's all I have. Thank you, Chair Fowler.
And thank you, Commissioner Bisco. Any other proposed amendments to the original motion? Commissioner Struthers?
I just want to first thank again, Commissioner Bisco. I thank you for your last part of that statement. That actually helps me understand where you're coming from, and I appreciate what you're saying, especially from that history of past. Sorry, brain pausing there, but thank you. I don't know how to phrase it as a amendment yet, but since we removed the weighing of evidence sentence, we removed that. There is what's referred multiple times in here. Throughout this document, there's this one sentence that reads, and I'll find an example. So on page, I'll use page 5. Page 5 under blasting for landfills cell preparation. There's a statement that reads, the Planning Commission finds the applicant experts, which we've now changed to consultants. I'll read that as that way. The Planning Commission finds the applicant's consultants evidence and the county's third-party reviewers evidence regarding interference with wells on adjacent properties to be less credible. And it's that less credible part that is referenced multiple times in these different sections that I'm not sure that goes back to weighing the evidence. We didn't weigh if one was more credible or not. And so I don't know if there's a way to change the word credible or less credible, or if we find those specific statements like that to remove them. So it's maybe more just a statement that I feel like we're still weighing the evidence in various parts where we say less credible, because we didn't really get into that.
Yeah, and I believe that the less credible is essentially a term of art, and ask Commissioner or Councilor Ryan to see if I'm accurate in that.
Thank you, Chair Fowler. It is a term of art. It's not necessary to keep that sentence if the commission chooses to strike it. As I mentioned before, under the striking of the weighing of evidence section, it is helpful for decisions to be sustained on appeal when it's clear that the Planning Commission did actually engage with all of the evidence and made a determination as to which evidence it believed more, but it's not necessary to the decision.
Commissioner Struthers, are you inclined to make a motion or accept it as it is?
I'm mulling. I want to hear what others have to say either on the document or that section. I'm not, as you said, trying to avoid wordsmithing. It's what I'm trying to avoid, but I just want to raise the point. It feels odd.
I
Chair
agree.
Fowler.
Oh, excuse me. I agree with Commissioner Andrew, and I feel as though so my whole point of struggling with this is not understanding the future uses of this document well enough. And I did try to ask about tonight's meeting well in advance. A month or so ago, I said, what are we going to be doing at this 29th meeting? Because July 29th meeting, because we've never done this before. So this feels like, words are important. Words have life, and we don't know what the life of this document is and the purposes and the nuances. So it is a very challenging moment to be looking at this and saying, I wouldn't say that, but I don't know how important my opinion is on this, or how, I don't know what's going to happen to these documents. So I agree with Commissioner Struthers that that statement does not ring true to me for the reasons that we discussed in the removal of the weighing of the evidence paragraph. But on the other hand, strategically, if Councilor Ryan is saying that this document has some uses that we are inexperienced with and cannot foresee the potential outcomes, it leaves us in a really awkward situation.
So in the interest of time, I'll ask again on this topic whether either Commissioner Struthers or Commissioner Lee would like to phrase their concern in the form of a motion.
I'm just raising it for the discussion at this point on the overall findings.
Okay, I see Commissioner Bisco's hand raised.
I guess to Commissioner Struthers and Commissioner Lee, I agree with their concerns about the actual word, and words do have meanings very clearly defined, and there are court cases, one on a period or a lack of a period, or a comma or a lack of a comma. I don't feel that that is reflective of the true nature of how we weighed evidence. I feel that words like inconsistent, deficiencies, inaccuracies, are more of the words that were used, both this evening, last week, throughout the hearing process and questions, and I know in my opening statement as well. I can't speak to everybody else's from memory. I'd like to see that type of a word, if it could be wordsmith, not wordsmith, but replace that. I'm sorry, I can't look at 6 documents at a time. Just a minute here.
Well, I'm going to jump in and again, if there is a motion to make a specific change, we can entertain that motion. But we're again approaching a dangerously close in both wordsmithing, and by doing the wordsmithing, dangerously close to coming back to deliberations. And we've already acted on the motion that we are not opening deliberations. So is there a motion, a specific motion on a word change?
I can try, but I'm struggling here to do it in real time here. So at the second to the last part here, the Planning Commission finds the applicant evidence and the county's third-party reviewers' evidence regarding interference with wells on adjacent properties to be inconsistent, internally inconsistent. Yeah, I can't do this. I have to do it with a pencil.
Well, I think the reason we are struggling with it is it's not an easy change. We may be uncomfortable with certain areas of the document. However, going further gets into wordsmithing, which is not appropriate. We need to defer to the professional staff that they have appropriately written this document based on observing our deliberations.
Chair Fowler.
Yes, Commissioner Bisco.
Excuse me. So I propose that we strike that last sentence. I'm trying to see where it all is at, but it generally reads, the Planning Commission rejects the applicant's, in this case, it's traffic experts' evidence, and the third-party reviewer experts' review of the evidence, and relies on testimony and evidence submitted by the opponents. I find that factually inaccurate. I feel like all of us have considered that applicants, quote unquote, experts, now changed to consultants. I make a motion that we just strike that statement where it exists in this document, which is both in the seriously interfere. The motion is that we strike that. I don't know how to categorize that last sentence.
Is it the one on blasting, Catherine?
Well, it is multiple times in here. So on blasting, it's the Planning Commission finds the applicant experts' evidence and the county's third-party reviewer evidence regarding interference with wells on adjacent properties to be less credible. I don't know that any of us said that. So that last sentence, but how do you go one by one? I'd move that we strike that sentence. The next one down is very similar. The Planning Commission rejects the applicant's consultant's evidence and the county's third-party reviewers' evidence and relies on the evidence submitted by opponents, including but not limited to, and that one goes on. So I disagree that we have rejected. I think we've considered seriously. I also disagree that we've relied on, and that implies only if we've rejected the applicant and their consultants, it implies that we've relied only on the evidence submitted by opponents. So I move that we strike, help me out, Chair Fowler, that sentence wherever it appears, and I think it appears in nearly every one of these. So does it have to be one by one, a motion?
Well, I think we should be highly cautious when there is such a wholesale proposed set of changes. And so, yes, it would need to be on each and every instance separately, but I will caution that this is a significant set of changes to a document that is has already been prepared by professional staff and is reflective of our deliberations on July 22nd. So I can entertain a motion if you have a specific motion.
So my motion is that we remove my motion is that we remove any sentences that refer to the Planning Commission rejecting the applicant's application and consultant evidence, relying only on evidence in testimony submitted by opponents. I think that will cover it. I cannot, reject is an inaccurate word for me. For my fellow commissioners, I don't feel like any of them said, I reject the applicant's expert testimony. I think they considered it very seriously, and a lot of it is valid, but I do and did hear inconsistencies. And I also do not in any way believe that myself or any of my commissioners, based on our conversations and deliberations, opening statements, that we relied solely on evidence and testimony of the opponents. So I think it's misleading at best. It's factually inaccurate at the outside.
So again, I'll ask for a specific motion.
Yes, my motion is to remove from the findings any statement that includes the words Planning Commission rejects the applicant's evidence and relies on the evidence and testimony submitted by opponents.
Is there a second?
I would second.
Further comments or discussion?
Yeah.
Commissioner Wilson.
Yeah. The only issue I have with that is that it doesn't read the same way in each of these paragraphs. In other words, in groundwater contamination, it goes on to, it says, we're saying the consultant's evidence, and then it goes on to, in other words, in that paragraph, it goes on to as that is it's like a prerequisite sentence to the following statement. And so then I don't know how much in that particular paragraph, how much we lose in terms of the context of the statement. That's just my comment about how that might work, and maybe others can speak to that.
Commissioner Fulford.
Maybe we can simplify, instead of saying rejects the applicant's expert evidence, maybe we consider it, but and just swap out rejects with consider. Because like Catherine said, we weren't throwing it out. It was like, yeah, that's good. This is a little better. And it was just weighing it back and forth. So maybe the word rejects is hardcore all the way to the left or the right, and considers is more of a kind of a middle of the road. We're taking the information in.
Commissioner Fowler, I'm sorry, I cannot find the place in Zoom where you hold your hand up. So I've been searching and searching for that. But I apologize for interrupting. But I think it's important to recognize what Commissioner Wilson said, is in that each of these findings uses a sentence that is worded differently and does not necessarily use the word reject. I mean, I think we should go finding by finding and look at them each individually.
So Chair Fowler, could I amend my motion?
You may withdraw your motion and make another motion.
So Chair Fowler, may I withdraw my motion and make another motion?
Please.
Okay. I I formally withdraw my original motion and I submit this for consideration to the Planning Commission. I would like to see, excuse me, my motion is that we replace the words "the Planning Commission rejects" with the phrase "the Planning Commission considered," and we replace the phrase, it's hard in that groundwater one, Commissioner Wilson, so give me a minute, you're right. Replace the phrase "and relies on" with "and considered." So we replace rejects with the word considered. We replaced "and relies on" with considered, which would then read to Commissioner Wilson's on the groundwater contamination, just the sentence that I'm focusing on. The Planning Commission considered the applicant's the Planning Commission considered the applicant's consultant, God. The Planning Commissioner rejects the, no, okay, we'll get it. The Planning Commission considered the applicant's consultant evidence and the county's third-party reviewers' evidence regarding groundwater contamination from leachate, and considered the opponent's evidence, including without limitations evidence submitted by. So that would be an example of replacing rejects with considered, replacing the word "and" or phrase "and relies on" with considered. For the next one below, traffic, for example, it would read: the Planning Commission considered the applicant's traffic experts' evidence and the third-party reviewer experts' review of that evidence, and considered testimony and evidence submitted by opponents. So it's a simple swap out of those two words, rejects and phrase "relies on" with the word "considered." So if you want
well,
sorry.
And no, you're fine, Commissioner Bisco. I'm thinking, I'm trying to I'm trying to coalesce. It makes, especially in that groundwater, and I'm going to use that as the example. So we are changing rejects, that one word, and we change it to considered. And we've already changed and voted on expert as consultant. And in that sentence, when you said considered, and considered the opponents, because I know in that sentence there's "and relies on." I'm wondering if you're okay with "and considered the opponents." I'm just adding the word "the" instead of "on." Okay.
So I'm not sure. So I think we're replacing two words, but the grammatical changes depending on what they look like in each one of these findings.
Yes.
Right.
And I defer to council to make sure that we're not just getting too far in the weeds.
We are definitely falling into the rewriting of a document with the risk of disrupting the fabric of the document as it was written.
I agree with that, Chair Fowler.
I do as well.
And so there is a motion on the table that has been made and seconded. I think we've exhausted comments. We'll now call for the vote. All those in favor signify by aye.
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 Opposed?
Aye.
Nay. So I'm going to roll call because I couldn't tell from the voice vote. I need to bring up my, let's see, Commissioner Bisco.
Aye.
Commissioner Fulford.
Aye.
Commissioner Struthers.
Aye.
Commissioner Lee. Commissioner Lee, I didn't hear you.
Aye.
Thank
Am
you.
I-
Commissioner Wilson.
Aye.
Vice Chair Heyman.
No.
And I vote no. The motion does carry. So this is the last call for changes. We are in the process of rewriting the entire document, and that is inappropriate use of a planning commission. So I will entertain one final call for specific corrections of errors. Then I will return to Commissioner Wilson and ask that you remake the original motion to include as amended.
Very well. Chair Fowler, in the matter of LU 24-027, I move that the planning commissioners adopt the planning commission decision, denial of conditional use permit report as amended by the planning commission, and the included opening statements of the commissioners that are also included, with the amended change of Commissioner Fulford's opening statement that it was revised and be included. Sorry.
Okay.
Oh, that was a lot.
No, I think we got the gist. Essentially, it is approving the document as amended through this proceeding. Do we have a second?
I'll second.
Very well. Any final comments prior to calling for the vote?
Just to clarify, an I vote is to support the motion that was made, correct?
Correct. An I vote is to support the motion to deny. So roll call. Commissioner Bisco.
Aye.
Commissioner Fulford.
Aye.
Commissioner Lee. I believe you're on mute, Commissioner Lee.
At least, can you hear me?
Yes.
Okay. Aye.
Commissioner Struthers.
Aye.
Commissioner Wilson.
Aye.
Vice Chair Heyman.
Aye.
And I vote aye as well. The motion carries to adopt the findings of fact and decision prepared by planning staff as amended through this meeting. A decision becomes final upon the date of the vote of the Planning Commission rendering a decision and adopting written findings of fact and conclusion of law. The just adopted written findings and findings of fact and conclusions of law is the final written decision of the Benton County Planning Commission. The final decision of the Planning Commission may be appealed to the Benton County Board of County Commissioners within 14 days of the Planning Commission's final decision adopting the written findings of fact and conclusions of law. The fee for appealing the Planning Commission decision in the landfill site zone to the Benton County Board of Commissioners is set forth in Board Order D 2023-091. The fee is the actual cost to the county of the appeal, with a $5,000 deposit due from the appellant on the date that the appeal is filed. This hearing is adjourned. And a comment to our audience, our next Planning Commission meeting will be August 19th. And so if you have an interest in observing additional Planning Commission activities, August 19th. And I'll also mention that we do have a vacancy on the Planning Commission. And if you have an interest in filling that vacancy, there is an interest form on the Benton County website. So thank you all for your patience and your diligence on getting this matter done. And I wish, Councilor Ryan, do you have a comment?
I just, this is I just wanted to say that I heard from the planning, I just wanted to confirm that the changes have, the planning staff has tracked all of the approved technical corrections to the findings that were made tonight, and that will be posted on the website tomorrow.
Thank you for that confirmation.
Sorry. Excuse me, Chair, for interrupting.
Very well, and now we are adjourned. Thank you all.
Thanks all.